Good afternoon and welcome to today's webinar, The Evolving Climate Change Litigation Landscape, the Rise of Consumer Deception Claims, sponsored by the Law and Economics Center at George Mason University Antonin Scalia Law School. I'm Ashley Evero-George, Associate Director of the Judicial Education Program here at the Law and Economics Center, and I'll be moderating today's discussion. This webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of legal and public policy issues confronting judges and policymakers nationwide. Our commitment is to developing original, high-quality law and economics research and educational programs like the one today to further enhance economic understanding and provide information that is useful in the legal and policy debates surrounding these issues. We thank you for joining us today to be a part of that ongoing dialogue. Our panel of experts today each come to the discussion with impressive backgrounds, researching, teaching, and analyzing the development of the climate change litigation landscape. So that we can reserve time for substantive discussion, I will give only a very basic introduction rather than the extensive bios. To learn more about each panelist, I recommend that you click on their names in the invitation you received from the LEC to join the webinar, or visit the LEC website at masonlec.org, where more details are listed. With us today is Andrew Cook, a partner at Warwick, Harrington, and Sutcliffe, and Professor John C. Dernbach, who is the Commonwealth Professor of Environmental Law and Sustainability, as well as the Director of the Environmental Law and Sustainability Center at Widener University Commonwealth Law School. And finally, we have Phil Goldberg, who is partner and co-chair of the Public Policy Practice Group at Shook, Hardy and Bacon. If you have any questions along the way, please submit questions using the Q&A box at the bottom of your screen. Each of our participants will speak for about 10 minutes, and then we will turn to intra-panel discussion before concluding with some time for audience questions. Please identify yourself in the text of your message if you do ask a question, and keep your questions short enough so that they can be readily incorporated into this virtual format. And with that, I will turn it over to Professor Dernbach to get us started. Professor?
Well, thank you, and it's a pleasure to be with you all. My job today is to outline the basic claims in the state consumer protection law climate change cases that are now pending. Point of disclosure, I don't represent any of the state or local governments that have brought these cases. I have not consulted with or advised their lawyers in any way. State and local governments have filed some 23 cases in state court against major oil companies for damages caused to them by climate change. They, as a whole, they claim violations of two kinds of state law. First, there are state common law claims based on public and private nuisance, trespass, negligence, and the like. And second, there are claim violations of state consumer protection laws. The gist of the complaint under both kinds of state law is that the big oil companies have known for decades that their products cause climate change. Yet their public statements continue to sow doubts about what was known, and they fail to warn their customers and the public about the dangers posed by these products. These cases are interesting and important. Examined closely, they do not line up, in my view at least, neatly with longstanding liberal conservative fault lines if you take the cases on their face. And I think these cases deserve to be tried in court, and believe the governments bringing them have a good chance of prevailing. Consumer protection laws have been around for a long time and for many good reasons. They protect consumers and the public from unfair, deceptive, or fraudulent sales practices. Markets tend to work better and more efficiently when consumers have accurate and complete information about what they're purchasing. To be sure, climate change is a global problem, but the damages being claimed by the government plaintiffs are local. And yes, oil companies and the products they sell play an important role in our lives. Nonetheless, these oil companies have an obligation, same obligation as other companies, to provide honest information about their products. So the consumer protection claims raise an important question. Would state and local governments be experiencing less severe climate damage if the oil companies provided accurate information about the public information about the climate change impacts of their products? And underlying this question is perhaps an even more fundamental question. should taxpayers alone be obliged to bear the significant and growing costs of climate change. I'm going to begin with some context, some legal context, and then discuss one of these cases in greater detail. In 2007, in Massachusetts versus Environmental Protection Agency, the U.S. Supreme Court held that greenhouse gases are air pollutants under the Clean Air Act. 4 years later, in American Electric Power Company versus Connecticut, state and local governments sued 5 major power companies for violating the federal common law of interstate nuisance and asked for a court order forcing these companies to reduce their emissions. The Supreme Court refused, holding that the Federal Clean Air Act, after Massachusetts versus EPA, displaced federal common law for these gases. In Native Village of Kivalina versus ExxonMobil Corporation, the Federal Court of Appeals extended that holding to also bar claims for monetary damage from climate change based on federal common law. The state and local governments in these 23 cases claim violations of state law precisely to avoid what happened in American Electric Power and Kivalina. Nevertheless, the oil company defendants removed these cases from state court to federal court, arguing that damage lawsuits for climate change go beyond the limits of state law and can only be decided based on federal common law. If accepted, of course, that theory derails these cases because, again, there is no federal law, federal common law of nuisance for climate change. In federal court, the state and local governments argued, not surprisingly, that these cases were filed and would be tried based on violations of state law. Without exception, the federal courts of appeals sided with them and sent the cases back to state court. In 2021, in one of these cases, BP versus City and County of Baltimore, the Supreme Court held that the Federal Court of Appeals did not analyze all the possible grounds for removal. After that decision, 6, I think, is the right number, federal courts of appeals fully analyzed the issue and still held that these cases belong in state court. The oil companies petitioned the Supreme Court to hear these cases again, but on April 24th, the court declined. So now we're back in state court where these cases started, and I expect that's part of the basis for this webinar. So let me look at one of them, Minnesota versus the American Petroleum Institute et al., filed in 2020. Until recently, it was much less clear what the oil companies knew about climate change and when they knew it. Beginning in 2015, that changed as investigative reporters and non-governmental organizations published detailed information based on internal company documents and interviews with former employees. Half of the 84-page complaint is devoted to a detailed description of what the defendants' own scientists were saying about the adverse effects of their products as early as 1965, and the defendants' intensifying campaign to sow public doubt about that exact point. The allegations in the complaint are confirmed by subsequent research. Earlier this year, an article published in Science showed that ExxonMobil's own scientists knew as much as, if not more than, the government and academic scientists about climate change. The article concluded that the company scientists correctly rejected the prospect of a coming ice age, accurately predicted when human-caused global warming would first be detected, and reasonably estimated the carbon budget for holding warming below 2 degrees centigrade, the point after which severe and severely damaging climate change is projected to occur. On each of these points, however, the company's public statements about climate science contradicted its own scientific data. Minnesota's complaint said the defendants' campaign of deception led to increased purchase and consumption of fossil fuels. As a result, the state says, its costs of adapting to and mitigating the adverse effects of climate are higher than they would have been otherwise. The state alleges that average annual temperatures in the state have increased 1 to 3 degrees Fahrenheit between 1951 and 2012, leading to an unprecedented combination of drought and catastrophic flooding. That in turn damages bridges, roadways, and stormwater and sewer systems. Higher temperatures worsen air pollution, including ground level ozone, all of which damages public health. And all of this, the state says, will get worse by 2050 if greenhouse gas emissions continue unabated, including billions of dollars in adverse economic effects. The complaint alleges 5 violations of Minnesota state law, a law on consumer fraud, strict and negligent liability for failure to warn, a separate law on fraud and misrepresentation, a law on deceptive trade practices, and violation of the False Statement and Advertising Act. For each of these, the complaint describes or quotes the relevant law and provides an element-by-element explanation of the applicability of the law to the defendants. For a remedy, the complaint asks for injunctive relief against violation of these statutes, public disclosure of the defendant's scientific research on climate change, a court order requiring defendants to fund a public education campaign in Minnesota on climate change that would be administered by an independent third party, maximum civil penalties for violating the state's consumer protection law, restitution, and disgorgement of profits by defendants Exxon, Mobil, and Coke of profits made as a result of their unlawful conduct. The complaint does not ask for court-ordered regulation of greenhouse gas emissions and does not ask the court to prevent the defendants from selling their products. In a parallel case in Hawaii, the trial court said this about the remedy being sought by the city and county of Honolulu. The plaintiffs expressly argue, the trial court said, that if the defendants make the disclosures and stop concealing and misrepresenting the harms, defendants can sell all of the fossil fuels they're able to without incurring any additional liability. Let me close by briefly addressing one additional issue. Unlike the tobacco cases, which are frequently cited as the model for this kind of mass tort litigation, where the money from the global settlement did not always go to anti-smoking programs or healthcare to the victims, the money sought in these cases would be set aside for abatement. In this case, that would mean adaptation measures to deal with sea level rise, droughts, floods, storms, wildfires, and other climate-related disasters. The idea is, and you've probably heard this idea before from other places, is polluter pays. And that's really the idea behind the claims. And the question they ask is the question I asked at the beginning, is why should taxpayers have to foot the bill for damages made worse by the defendant's deceit? Thank you.
Thank you so much. And for those of you watching, please remember that you can submit questions using the Q&A box at the bottom of your screen. And now we will turn it over to Philip Goldberg. Mr. Goldberg, please take it away.
Great. Well, thank you so much, Ashley and Professor, for the introduction. Hopefully you guys can hear me okay. Am I good, Ashley? Great. These have been fantastic series of webinars that the Law and Economics Center puts on. And, I remember when they happened on the Hill and we had great barbecue, and Donald promised me that he would deliver barbecue to my office today for this lunch, and I did not get any. So, I'll have to take that up with Donald. But these are great programs, and I end up learning a lot from my co-panelists. And I think, the discussion that we have is really high level. In addition to my work at Shook, Hardy & Bacon, I'm special counsel to the Manufacturers Accountability Project, which is a project of the National Association of Manufacturers. And the concern that we have about this kind of litigation is that it puts aside traditional liability principles about what people are liable to, why and how much, and what it tries to do is to make manufacturers and others pay for what are really social or political or environmental issues that have much broader and more common concern. And it's not really about corporate misconduct. It's much greater than that, as climate change is. And so I think I'll start, and I often do in these kinds of things, where I think we all agree, and then certainly where I would agree with Professor Dernbach, and that is that climate change is a serious problem. And I don't think that anybody is denying that at this point. And it certainly needs to be addressed, and it needs to be addressed at the global level and certainly at the local level. When we look back over the past 150 years, electrification has been considered one of the greatest advancements in human health and standard of living, allowing us to refrigerate food, heat and cool our homes, obviously the whole transportation network and the ability to get around. And that has propelled society in so many phenomenal ways over the past 150 years. And we all agree that the way we've done that for that 150 years is not going to be the way we do that going forward. That we need to be able to live and sustain our modern society while also being able to sustain the planet and be able to do so in an affordable way for consumers. And so that's, I think, the baseline of kind of where, certainly where I think we agree. Where I think we disagree is on the value of this litigation for achieving those purposes and trying to address climate change in any kind of meaningful way. Put simply, this litigation isn't going to do that. It's not going to help advance any innovation. It's not going to do any of the things that we need to do as a society in order to reduce emissions. And it, as we'll get into a little bit later, has no legal foundation, traditional liability principles, and frankly, is an unproductive distraction from what really needs to get done. I agree with much of what Professor Dernbach said in terms of the historical foundation for these cases, and I just want to kind of overlay some thoughts to the background that he laid out. Early on, it was clear what this litigation was about. And I remember doing seminars that, is litigation, the right way to regulate greenhouse gas emissions? And this, 10, 15 years ago, that's really what everything was all, or I should say 15 years ago, what all this litigation was about. And it was about that on its face. And so when you had AEP versus Connecticut, where it was about using, public nuisance law and federal public nuisance law to try to regulate the utility industry, and the court said, no, you can't do that because the Clean Air Act has displaced the federal common law, as the professor said. But the court went beyond that and explained that it's really not the role of the courts to get into this kind of subject matter, to try to regulate and figure out climate change and emissions. And they said, you don't want courts doing this on an ad hoc basis. It's a good thing that we've got the EPA, we've got the regulatory bodies that are focused on this. And then when the issue went to the Ninth Circuit in the Kivalina case, it was presented slightly differently. So the first round, there were about 4 different cases, and they all tried to present the public nuisance case in a slightly different fashion. Some were by private plaintiffs, some by government plaintiffs, some were seeking injunctive relief, some were seeking abatement or damages. Some were under federal law, some were under state law, some, they tried all these different combination of permutations. And what Kivalina court said, the Ninth Circuit said is, that's not the point here. What the Supreme Court said is these cases aren't for us to decide. These issues dealing with climate change are just not, it's not about liability and justiciability. It's about public policy, national, international issues that need to be resolved at, the political branches of government. After that, the folks behind this effort got together and put out a report to explain that they thought that litigation was still their best way to try to jumpstart the kind of policies that they wanted to see. And they said, and I'm quoting here, that even if your ultimate goal might be to shut down a company, you still might be wise to start out by asking for compensation for injured parties. And they understood early on that 2 things. One was that they wanted to put pressure, public relations pressure, and they talked about creating scandal and trying to delegitimize the companies from engaging in policy discussions. And the second thing was they needed to get away from the federal court. So they were desperate to make these state claims. So they said, the Annapolis lawyer, he said, we're confident our state courts will get us there. They would like to have their local courts rule on these things as opposed to federal judges. And so they they first started bringing these cases under state public nuisance in order to try to avoid the federal courts. And as Professor said, that debate for the past 4 or 5 years has been about which ballpark should we be in? Should we be in the federal courts or in the state courts? And that's now been resolved because the Supreme Court didn't take the last set of cert petitions. And so we're pretty much headed towards state court. But as part of that effort, there was a shift to these Consumer Protection Act claims. And I think in large part for 2 reasons. One is because they felt that state statutory claims under Consumer Protection Act had a greater chance of not being removed to federal court than state common law claims. And so looking for a state statute to bring state statutory claims that they thought would do that. The second thing is, if they were focusing on trying to create this scandal, trying to create this, because of the campaign of deception, going to a law like consumer protection seemed to be more on point, even though it's not, and we'll get into that why, but at least it's about speech. And so they thought that would help focus their attacks on the industry kind of in that way. Whereas the public nuisance claims proved in court to really not be about speech or what companies said. And in fact, in the New York case where the federal courts, the Second Circuit threw out the New York's climate case, this issue never really came up. And then in the city of Oakland's case, the attorneys said, it's really just a plus factor for us. It's not what we're basing our public nuisance liability on. And so we've seen this shift to Consumer Protection Act because it helps advance the messaging and the narrative to try to, in their words, delegitimize the companies, create the kind of scandal they want, and try to help drive some of the outcomes that they want to see, the regulatory and political outcomes they want to see outside of court. And even if they can use the court to try to do that, and the state courts do that, they're obviously hoping to do so. So I'll stop there. I don't know if I've used my time, but I know Andy, I'm sure, is chomping at the bit to jump in. And so I'll pass over to Andy. And I think my screen's gone a little dark, so I don't know if that's, if I can figure that out while Andy's talking. So Andy, go ahead.
Thanks, Phil. Appreciate it. Thanks to Donald, Ashley, for having me. I really appreciate it. I'm coming from this from the perspective of businesses and energy companies. Consumer protection laws provide state attorneys general with sweeping authority to address improper business practices. These consumer protection statutes in the states are known as unfair or deceptive acts and practices, or UDAP. And these statutes broadly prohibit conduct that is deemed unfair or deceptive. The broad and open-ended nature of these terms provide substantial power to state AGs. As a former Chief Deputy Attorney General for the state of Wisconsin, I have firsthand knowledge of these statutes and how they operate against businesses. And now in private practice, I know what it's like to represent businesses on the receiving end of the complaints. So based on my experience on both sides, most state AGs responsibly apply this broad authority to protect their consumers on one-of-the-mill consumer protection cases. In recent years, however, some state UDAP actions or consumer protection actions have strayed from their intended purpose of protecting consumers in 2 really specific ways. First, these cases are typically not started by consumer complaints, but are developed by private lawyers who pitch the cases to state AGs or local governments to pursue litigation on the state's behalf. Second, the cases often target lawful products that are regulated by government agencies charged with protecting the public. On top of this, state AGs and their hired outside counsel typically request the maximum civil penalty authorized for UDAP violations. They often allege that every product sold, prescription filled, letter sent, or advertisement published is a separate violation. Using these broad UDAP statutes, states can extract hundreds of millions of dollars at a time from businesses. And actually some are now starting to reach into the billions. This results in a wholly unpredictable system with wildly varying penalties that raise significant due process concerns. In the absence of traditional common law protections, companies struggle to predict their exposure. Businesses accused of failing to warn of a product's risks used to be able to rely on certain basic common law protections. For example, plaintiffs asserting such tort claims need to offer individualized proof of causation and actual injury. But states across the country have severely curtailed those protections through cases using these consumer protection claims. These statutes transform what are previously ordinary product liability claims into massive claims that require no such individualized proof of injury or causation. The expansive use of UDAP or consumer legal theories by state AGs isn't unique to current climate change cases. In fact, the proliferation of UDAP or consumer protection claims by state AGs started with the tobacco cases and most recently moved to opioids lawsuits against many of the distributors and against even the pharmacies who were simply filling doctors' prescriptions. State AGs and their plaintiffs' firms' use of UDAP legal theories has expanded also now to PFAS chemicals, pelvic mesh, vaping, and other products. In fact, the latest UDAP claim against Coca-Cola involves the company's statements about its plastic recycling program. Just goes to show that, goes to prove that no deed goes unpunished. The rapid increase in the use of UDAP legal theories is not an accident. It is a direct result of the troubling trend of state AGs hiring plaintiffs' firms on a contingency fee basis, who are often funded by third-party litigation funders. And the use of outside contingency law firms is not a partisan issue. Both Republicans and Democrats hire outside plaintiffs' attorneys and use these consumer protection claims. So now switching over to the climate change cases and talking more directly about those. The current climate change litigation, however, is political. It's being brought by Democratic state AGs at the behest of plaintiff firms and environmental groups. They're trying to get done in the courtroom what they are unable to get accomplished legislatively or by regulation. This coordinated effort began in 2012 when a number of environmental groups and plaintiff lawyers convened in La Jolla, California, to launch the current litigation efforts. 4 years later, it resulted in numerous state AGs and local governments meeting with former Vice President Al Gore at a press conference to launch the current climate change litigation. As both the professor and Mr. Goldberg highlighted at the outset, that the lawsuits have now mushroomed to numerous states and local municipalities. As I mentioned at the outset, to be a violation of a UDAP or consumer protection law, the act must be either unfair or deceptive. Despite this broad language, the climate change lawsuits fail miserably as none of the conduct by the energy companies can remotely be considered unfair or deceptive. In fact, as I'll discuss in a moment, the very governments suing the oil companies not only regulate oil as a lawful product, these same governments also promote the use of oil in the US and are some of the biggest consumers of oil and gas themselves. Again, to be liable under consumer protection claim, there must be some alleged deceptive act, but none of the oil companies' conduct or statements in producing and marketing their products comes close to being deceptive. For many decades, scientists around the world have studied the link between greenhouse gases and climate change. And although scientific, governmental, and public knowledge about climate change has increased substantially over time, it is undisputed that the potential climate risks of fossil fuels have been widely recognized and reported on for decades. Policymakers in the United States and around the world have long been aware of robust scientific research on these important issues and have considered the difficult public policy questions relating to energy security, economic growth, and environmental protection that arise from these long recognized risks. The difficulty of these complex balancing decisions have been starkly demonstrated by rising energy prices in recent years, exacerbated by the war recently in Ukraine. These pressures have led to the Biden administration to call on energy companies, including the very defendants in the current climate change cases, to expand production of fossil fuels, urge OPEC nations to produce and release more oil, and take executive action to release millions of barrels of oil from the Strategic Petroleum Reserve, despite its recognition and concerns regarding global climate change and its stated goal of reducing carbon emissions. So any allegation that oil companies deceived or misled federal, state, or international regulators or the public at large about the potential impacts of increased greenhouse gases on the climate is belied by a historical record replete with public information, including scientific reporting, international, federal, and local policy discussions, in lawmaking and national and local media coverage. The vast and comprehensive study and discussion of climate change clearly refutes the plaintiff's allegations that oil and gas industry had secret, quote unquote, secret knowledge about the link between combustion of fossil fuels and its impact on climate change. Despite this widespread knowledge of potential adverse climate impacts related to increased carbon dioxide in the atmosphere, the United States, like the rest of the world, has continued to rely on and promote oil and gas for its energy supply. In fact, former President Barack Obama understood the need for more oil and gas. Here's a quote from a speech he gave in 2012, quote, "Now under my administration, America is producing more oil today than any time in the last 8 years. That's important to know. Over the last 3 years, I've directed my administration to open up millions of acres for gas and oil exploration across 23 different states. We're opening up more than 75% of our potential oil resources offshore. We've quadrupled the number of operating rigs to a record high, and we've added enough oil and gas pipeline to encircle the earth and then some," unquote. From the 1990s, domestic consumption of oil and gas has increased by 20% and 57% respectively through 2018. In 2018, the United States consumed more energy than ever before, when fossil fuels accounted for 80% of the record-breaking consumption. Despite this increase in consumption, the U.S. Energy Information Agency has recognized that the switch from coal to natural gas, quote, has helped reduce overall U.S. CO2 emissions growth because natural gas is the least carbon intensive of fossil fuels used in electricity generation. Like the federal government, each of the states that have sued the oil and the companies in these cases have continued to encourage and promote fossil fuel. It's therefore extremely peculiar and quite frankly wrong, in my perspective, that the very states who not only promote oil and gas, who are some of the largest consumers of oil and gas, can turn around and allege that the energy companies somehow deceived them. So in conclusion, even under the broad consumer protection statutes, the government plaintiffs' claims are meritless and should be rejected at the motion to dismiss stage. So with that, thank you very much and look forward to further discussion.
Thank you very much, Mr. Cook. Before we move to an intrapanel discussion, or a broad intrapanel discussion, let's take a couple of minutes and turn it back to Professor Dernbach for any reaction or response to remarks from his fellow panelists. Professor Dernbach.
Well, thank you. This is all very interesting hearing the perspectives today. And I should say, Andy, we should probably talk about Wisconsin after this because I grew up in Eau Claire. And we can have a longer conversation about that. But in any event, I think the question that the state and local governments are asking is not whether the oil companies have added value for America. That's not the question they're asking. They're not asking about whether, and they're not saying shut it all down now. The question that they're asking is fundamentally this: knowing what the oil companies knew, what their own scientists knew as early as 1965 about the impact of their products, how should they have handled what they had to know would be a transition of some kind from the use of their products to other forms of energy? That, I think, is really the question, is how did they think about managing the transition? When you find out you've got a product that's got a problem, typically, I think the idea would be to try and fix that in some fundamental way, with as much reasonable speed as you possibly can muster, and we don't get that here. What we get instead, these are the allegations that are being made, is not that that governments were unaware of the science, because governments were aware of the science. It's not that the Intergovernmental Panel on Climate Change didn't exist, because the Intergovernmental Panel on Climate Change does exist, and it continues to collect peer review information. And every 5 years, it issues a report that is more and more certain about and precise about the impacts of climate change. The question rather is what the oil companies knew, and simultaneously what the oil companies were doing about what they knew. The argument is that the oil companies knew their products were causing problems. They knew that with greater and greater levels of certainty as each decade passed. And at the very same time, they were more and more forcefully advocating positions that were inconsistent with what their scientists already knew. And they were casting lots and lots of disinformation out to the public. They were sowing doubts about the exact same points that their scientists were making, and that looks to me a lot like it has some element of deception in it. Now, I'm not going to decide these cases, and none of the people on the panel are going to decide these cases. But a question is that a reasonable question? Is that a reasonable thing to put in front of a jury? Would a jury decide? Might a jury decide? Should a jury decide that if all of the things being equal, that the people in the state of Minnesota might have managed their consumption of fossil fuels differently if at the same time these companies were selling the fossil fuels, they were also telling the truth about their impacts and perhaps even inviting a public discussion about what to do. That, I think, is the thing that the oil companies, that I think is really at the heart of this.
So if I can jump in, Ashley, that
No, please go ahead. Go right ahead.
no, and I think, a lot of what Professor Dernbach just said, about the, that the debate and the dialogue that this litigation is trying to put forward is about, managing the transition to energy production and advancing of certain policies and regulations and what you think about those kinds of things. Those are not what consumer protection acts are designed to govern. Like those are regulatory and legislative matters. They're issues, they're matters of public policy. There's a lot of factors that go into it, from affordability for people to energy security to national security, as we've seen obviously over the past couple of years with the war in Ukraine and the impact of fuels to that security debate. What consumer protection acts are about is making sure that consumers receive fair value for their purchase. So that if you went to buy a gallon of gas or you went to buy, a bottle of soda, did you get the value that you were supposed to get for that? Did it give you the energy, the gas give you the energy you wanted? Did you get, the right soda or beverage in the bottle? And so it looks at things like, the advertisements that companies make about their products or their services. It looks at labeling, what's on the label of a product, and is it accurate? It's making sure that all the dialogue and everything about a Consumer Protection Act is focused on that transaction and about the dialogue over the products and services. All the things that we're talking about here are about policy issues, are about how we manage this transition, how what people said about about their views of regulations. And you look at some of these lawsuits, and Andy mentioned the one against Coca-Cola, and the Attorney General in DC has a similar one against the energy industry. And if you look at parts of the complaint, they say, the Attorney General says that these companies shouldn't even be able to talk about truthful things about what they're doing on the energy transition, on clean energy, on investment in reduction of emissions, solely because they sell oil and gas. Because they are energy companies, they should be silenced and not be able to say truthful things about what they're doing. That's what the Coca-Cola case is about. It's saying because they're a company that sells plastic bottles, they're not entitled to talk about recycling or environmentally friendly views. And so that's the political nature of this litigation. It's about silencing, it's about trying to create scandal, as I mentioned before, but then it's also the remedies they want are saying they shouldn't even be able to talk about these things. And with the things that they shouldn't be able to talk about are all about policies, are all about regulation, or all about what legislation they support or don't support. And that's not what consumer protection acts are for, but that's what all the complaints say. And so that's what the concerns that we have, because that's not what these laws are meant to protect. And that's what we want to make sure that the laws stay focused on.
Yeah, if I can jump in real quickly, it's great to have a fellow Wisconsinite on, Professor. It's great. Look forward to that conversation. Going back to the deception argument, again, not to really be a broken record, understanding that early on there may have been, they may have known certain things, but about CO2 combustion, CO2 and combustion of fossil fuels. But that really doesn't hold very much weight. As I noted, there's so much literature on this. This has been known for many years, going way back to the 1960s, 1950s. This wasn't a secret. There are a number of government and quite frankly, international studies on this. So that argument to me is a bit flimsy. And then going forward, as I just noted before too, how these states have continued to consume oil, again, not only to regulate it, but then they also promote it, and are take the proceeds from this gas taxes, oil taxes, etc. There's really no deception taking place. It's really hard to square that with any deception. Another thing I'd just say real quickly is these cases are looking to hold the major oil companies liable for all of the CO2 emissions that have been produced. When quite frankly, there's varying percentages, but some show that they only produce roughly 1/4 of all CO2 emissions. So you're bringing these cases to force all of the oil companies to bear all the costs for the CO2 emissions out there, and letting others off the hook. So with that, I'll turn it back.
I'll just jump in with a quick reminder to the audience again that you can submit questions using the Q&A box at the bottom of your screen. But before we move to audience Q&A, are there any other comments, questions, things that the panelists want to add to what you've heard during the discussion so far?
Can I just throw in a couple of quick points? So the question, I think, about the consumer protection laws is the consumer getting value for the money they're spending? I think that is the question that Phil asked. And I guess what I would say is that if the consumers knew that there were adverse impacts coming from the same product, would they be as comfortable purchasing the product as they might otherwise? And a big tax bill down the road is not exactly what most people sign up for when they buy a product. So that's just a quick first point. The second point is information changes behavior. We know that. For example, the product labeling on various products that you buy at the store, the nutritional content and the rest, I expect a lot of us in different ways are affected by that. And here again, if the oil companies have been telling the truth about their product, instead of casting disinformation about it, consumer behavior might have been different. And then finally, this is not about liability for all carbon dioxide emissions. That's really not what the cases are asking for. What they're asking the companies to pay for is a provable share of the damage that the particular state and local governments are experiencing. And that's just straight up on the face of their complaint.
A lot of this has been looked at, and a lot of this stuff has been online for years. There was a case in New York that was brought, kind of focusing on, who do what and when. And, it was originally supposed to be brought as this big case that was going to, expose, everything. And it kept getting winnowed down because they couldn't prove anything, even with all the information, with all the discovery, with everything that was made available. And at the end, the state court in New York said that the claims were, quote, hyperbolic. and that, about, whether there was deception and what have you. And so, the claims have not really borne fruit in any kind of legal proceeding. There's a lot that's talked about. It's makes for good headlines. It makes for for great conversation. But when you look at what the legal import of what of what people say and whether or not there's a legal impact from that, the courts have said there hasn't been. Those that have looked at it, and in large part, that is that's because there may be, and to Professor Dernbach's point, there may be information that if I know about something that may affect my purchasing decisions. I may not want to frequent certain stores or restaurants because of what political bent they might have. I may not want to use a product for whatever reason, because I may not agree with, for ideological reasons, just because information might affect my personal subjective purchasing decision, doesn't make that subject to a Consumer Protection Act claim. Consumer Protection Acts are dealing with, factual, verifiable information that are material to the reasonable consumer with respect to the value they're getting for that product. And so, again, this is a complete novel use of the Consumer Protection Act. It's not based on how these statutes have ever been applied before. It'll be interesting to see how the courts look at this, but if they apply the law as it was intended to be applied and how it's always been, it would be to then dismiss these cases for failure to state a claim under them, because that's not what the whole dialogue we're having around this is not what these statutes govern.
We have a few questions coming in from the audience. I'll go ahead and ask one of those. So we have one question. How do studies on the risks of burning fossil fuels absolve the oil and gas companies of their specific knowledge that their products would destabilize the climate? How does it absolve them of their deliberate deception?
Bill, you want me to take that, or?
Yeah, that'd be great. I'm not sure I understand the question, so go ahead.
I think the question is that that they somehow are not absolved for their production and marketing of oil and gas. I go back to what I said at the outset. These companies are not only producing a product that is legal, very legal, from not only encouraged but and promoted by governments, but they also are, if you look at governments and how much United States and each of the states themselves, the large amount of oil and gas that they consume from the oil companies does absolve them. I think it's hard pressed to somehow find under a consumer protection standard, even at the broadest reading of a consumer protection statute, how you can find an oil company liable for a legal product that they produced and marketed does not pass the muster under the consumer protection laws.
If I can just add a quick point here, and maybe I haven't been clear enough about this point, but it's really the disinformation campaign. It's the systematic effort by the oil companies to provide a different message about the impacts of climate change, and to say this is not a problem, the causation hasn't been proved, we're really looking at global cooling, and on and on and on and on. That's really where the deception is occurring. It's not that, as I say, the public science is wrong, but that's really where this has been an issue. Just one quick thing on Phil's point. He talked about a New York case. The New York case came out the way that Phil said. It was an investor protection case, not a consumer protection case. And the curious thing about that is they apparently couldn't find any investors who were willing to testify. Now, I think you may get different issues at trial here, but I just wanted to point out that that's a bit of a distinction from what we're talking about today.
Yeah, this does have the feel of, throw as much legal spaghetti on the wall and see if any of it sticks. And I feel like that's what this litigation has looked like. And whether it's been, public nuisance, investor, consumer, everything, how do we try to find something so that, so that we could try to, suggest that there's been, there needs to be a liability here. If you look at people, when you talk to people who are involved in the discussions in the 90s and 2000s and even more recently, I did one of these panels with Congressman Melanson from Louisiana, and he said, we all knew, like, there was no deception here. There was no confusion about whether fossil fuels were contributing to climate change. The challenge of moving towards, this transition that Professor Durlach talked about, it's, there's regional differences. Some states are more coal-based, some were more nuclear-based, some were more oil and gas-based. So everyone's looking at this from their regional perspective and what the pocketbook impact is going to be for their constituents. A lot of it was just straight political, not letting a certain president get a win on an important issue. A lot of it was concern about constituents or concern about other things. And so to suggest that somehow that, an advertorial here or there or what have you, somehow it is the cause of climate change, I think doesn't even, withstand, the smell test. And frankly, that's probably the deception here is some of those allegations.
Here's a question for all three of our panelists. So we've been discussing that theories in climate change litigation have been evolving. What do you predict is the next evolutionary development we have yet to see?
I've learned never to underestimate the creativity of those who like to bring lawsuits. So I'm sure they're hard at work in their laboratory coming up with the next, the next theory of liability. It's it almost feels like, again, it's throwing spaghetti up on the wall. I think we're going to stick probably with this until we see how these play out. But I don't think we're going to see the end of this kind of litigation because it's being funded and driven by people with purposes that are not necessarily about winning in court. It's about filing lawsuits, using the lawsuits for media attention, trying to drive political interest, and that dynamic is going to continue on. And so it's just for them a question of how do we keep these cases in court and then leverage them for the purposes that we want to get out of it.
Yeah, go ahead, Professor, if you want.
Well, I worked for a long time in government, like Andrew did, and one of the things I learned in government was to try and stay away from people's motives. They're more complicated than you think, and I try to look simply at what people are asking or alleging or asserting. And what I think we're going to see next is, I think what we're going to see next probably is the first case to advance maybe in Hawaii. The trial court seems like it's ready to go in terms of discovery and the rest. There's a motion by the fossil fuel defendants that I think is now in front of the Supreme Court. I think the Supreme Court of Hawaii is probably likely to dismiss that, and I think that's probably the case where things are going to proceed next. But across the country, I'm not going to try and venture any more than what I just said.
If I can real quickly, I won't predict in this litigation per se, but my concern is on the expansive use of UDAP. I've already talked about how it's started from tobacco, went to opioids, now is going to PFAS. Any legal product is, if these cases continue to be successful in state courts, are fair game for lawsuits. And I go back to the fact that there's serious due process problems for companies who are heavily regulated and who are following the law, and not only following the law, but are promoted and encouraged to follow the law, could eventually be on the hook for untold millions, hundreds of millions of dollars. So it's a problem, it's a concern, longer trend.
In our final 5 minutes, are there any other comments or questions between panelists that you'd like to ask based on what we've discussed so far? All right, well then I think we'll end just a few minutes early today. I want to thank each of our panelists for taking the time to join us and discuss this topic, and thank you to the audience for tuning in. Please visit our website for more information on the next webinar, and thank you again for joining us. Have a great weekend.